Nothing has been brought so far that warrants any action on his part. And if those accusations are proven to be true, or even if sufficiently credible evidence is brought to warrant a charge, then that's a different thing.
Hello, JPU family. Welcome to another episode of Jamaica Politics Uncovered. I hope you guys are all doing well today. You're having a productive week so far. This video is longer than usual for a video upload for us over here. So clearly, there's quite a bit in it. So I ask for your patience. Now let us start at the beginning of this video. You heard the opening where Mark Golding was basically saying if sufficient evidence come about and, if evidence comes, then it's a different story. He was making reference to Dayton Campbell when he was accused of being a pedophile. The case is now in the Court of Appeal. It's not even completed. But at the time, at the beginning, Mark Golding said, hey, he's not going anywhere. And it's been, 3 years worth of court proceedings. And Mark Golding never one day suggested or even accepted the suggestion that Dayton Campbell has become a major distraction, So at this time, Mark Golding does a complete 360. He's telling Andrew Holness that he needs to resign. Based on what? Based on nothing. The Integrity Commission's final report says that they have no evidence, no data that Andrew Holness had illicit enrichment. And the other thing about his bank account that his parents put him on, they referred him for prosecution. The prosecutor said they're not prosecuting. So there is nothing as of right now that find Andrew Holness guilty of anything. But Mark Golding is in Parliament and all over the place saying that the Prime Minister should step down and they're trying to move no confidence vote against the Prime Minister. Now, I am going to let you listen to an article that was written by attorney at law Gordon Robinson, who is located in Jamaica. He blogs on Twitter, I think, sometimes, and other spaces. But this article, I find it very interesting, and I want you to have a listen. Then I'll come back and talk to you and give you also the update where this IC report debate is going on and the continued attempt of the opposition to overthrow the government. So have a listen.
Politics over country, always. Illicit enrichment? Are you sure? Illicit enrichment is defined as procuring a significant increase in a public or private official's assets, which cannot be reasonably explained in relation to their lawful income. That was the only matter Integrity Commission, IC, told PM August 18, 2023 letter it was investigating. Nobody told him it was investigating possible tax evasion, which is not illicit enrichment, and is the purview of Tax Administration Jamaica TAJ, a separate statutory authority with a different mandate or other financial crimes, purview of MOCA or FID. So let's stick to the core issue. Remember, we are looking at assets, not activities. No company is a shareholder's asset. Shareholders' assets are their shares. How were the shares acquired? How much actual equity did the public official inject into the company? What's the share's value? Is that value disproportionate to the official's lawful earnings from all sources? Regarding lawful earnings, a public official who comes to public service after a lifetime of owning, operating various businesses, whether personally or with family, is, from the get-go, of means independent from her salary from the public purse. That official is permitted, subject to certain conflict rules and parliamentary procedures, to continue these businesses. So the concept of a man of independent means having 28 bank accounts and able to control the movement of funds among companies in which he's director shareholder ought to be about as exciting to anti-corruption agencies as a William Hung concert. Unless, of course, it's proven that the funds weren't lawfully earned. Remember, enrichment is allowed, encouraged even. It's illicit enrichment that's bad. Public official salaries aren't the sole criterion to compare with assets. All lawful earnings are taken into account. So, in corporate language, we should look at PM's balance sheet. We should pay attention to assets liabilities and set them beside lawful earnings. IC found PM failed to disclose certain assets, namely unaffiliated bank accounts, for which he was named as emergency contact or for other reasons unconnected to ownership. So IC Director of Investigations, DI, referred this obviously inadvertent omission to IC Director of Corruption Prosecution, who again refused to prosecute. Nothing else was referred for prosecution. When the trumped-up charge of false declaration was rebuffed, PM's statutory declarations were again referred to DI, IC Report, paragraph 3.13. The basis for the second referral was out of concern that inter alia, Mr. Holness owned assets disproportionate to his lawful earnings. What? Nobody noticed this salacious suspicion before while scrutinizing every minute to find something to use to prosecute PM? Only after the false declaration needle in the investigatory haystack failed to stick anyone did IC notice this big crime possibility and began a second investigation that ended in a lengthy, loud expulsion of sound and fury. Signifying the square root of nothing? Sheesh. Anywho, let's look at how IC investigated possible illicit enrichment. IC insisted paragraph 314. The focus of this report is the second referral investigation. But is it? At paragraph 32, IC listed other government agencies from whence it sought info, including Taj, but not FID. Why would it want info from Taj to investigate asset income proportionality? Why, having received info from Taj, would it be still asking Taj to conduct a separate investigation into corporate tax returns already in Taj's possession? Where's the beef? How would that lead to a finding for or against personal illicit enrichment? What's going on? Non-payment of company profits tax, if such be the case, has nothing to do with whether or not a shareholder director may be guilty of illicit enrichment. Remember illicit enrichment? In one hand, assets. In another hand, earnings. Do they balance? Do they proportionate? Corporate assets don't belong to shareholders. Earnings are personal earnings from all sources, including corporate dividends declared by company directors. These are readily available in every company's accounts. So why did IC need an international forensic accountant? What did she do? Why have we not been shown her report? Why does IC need a Taj investigation in order to discover whether enrichment by increased share value is illicit? And what about Naomi? At paragraph 32, IC revealed its real intent, which was to go beyond an investigation into possible illicit enrichment. After listing possible illicit enrichment as one of its purposes, 3.2c, it added whether PM D breached the Parliamentary Integrity of Members Act, Corruption Prevention Act, Integrity Commission Act, Income Tax Act, or any other applicable legislation, and E was associated with any businesses, and if so, the nature and extent of this association. So now, association is illicit enrichment? Geez Louise, did the August 18th letter inform PM of this mud-tossing at walls exercise? Unless IC is trying to prove some sort of political connection to these businesses, such as unfairly awarded government contracts and or kickbacks, which they have zero reason to suspect, why the Granny Gungus Natty are they? Casting their nets so wide? For so long, they concentrated on 5 omitted bank accounts. Pages and pages of this report are wasted regurgitating IC's concerns because these accounts were omitted from PM's statutory declarations. That wild goose chase having caught zero poultry, suddenly PM is treated like Al Capone. Why? IC goes around the world in 14 pages 42 to 56, citing complex judicial decisions ad nauseum to define illicit enrichment. But this column's first paragraph proves it only takes 3 lines. Eventually, at paragraph 5815, IC states definitively, in making an assessment as to whether a declarant owns assets disproportionate to their lawful earnings, it is necessary to examine the declarant's assets, liabilities, and income over a period of time. Alrighty then, finally, assets, liabilities, income. So, how come, at paragraph 5.95, page 132, after reams of hyped-up revelations regarding Andrew Holness's company's activities, their ability to finance loans, acquire property, and their tax returns, DI was not in a position to determine illicit enrichment using source and application formula. To do so, the DI would need to determine the total amount of funds applied towards the acquisition of wealth, assets, or saved over the relevant period. This was not possible as the DI was not provided with a schedule of Mr. Holness's expenses covering the relevant period. What in the sweet Fanny Adams do expenses have to do with assets, liabilities, or earnings? What were his legitimate earnings? Could they finance or facilitate the financing of his assets? Why do you want to see his expenses? Are you a private dick trying to dig up dirt for a family law proceeding? Why do you care whether these assets were acquired by savings or loans? The fundamental question remains, are the assets disproportionate to earnings? So the DI is not sure if there was illicit enrichment. Anywhere in the world, in any judicial or quasi-judicial forum, not sure automatically leads to a verdict or finding of not guilty. Are you sure that I will still be down when you've realized that you've been blind? Think before you answer. Are you sure? Are you sure? There are no mulligans in criminal prosecutions or corruption investigations. As my sainted granny used to say, it's eggs or young ones. Instead, IC facilitates this forever song and dance routine, as if it cannot bring itself to make any other finding, but an adverse one, so must entreat every available financial crime unit to help it arrive at that conclusion. I've seen this attitude, method, and style before. IC's predecessor, Office of the Contractor General, produced voluminous reports, including one about contracts awarded by St. Anne Parish Council, and another regarding a sublicense Caymanas Track Limited was forced by Commercial Realities to acquire. In those reports, the good names of an honest MP, of independent means, and honorable citizen, who repeatedly contributed time and talent to national projects, were unnecessarily denigrated. Not one criminal prosecution alleging any act of corruption arose from any of these vitriolic verbosities. It's as if professional prosecutors won't touch any of the masturbatory missives with a barge pole. I predict nothing legal will come of this latest vulgarity, but immense political damage will be done. The staple singers Roebuck, Pop Staples, and Children, Cleotha, Purvis, Mavis, and Yvonne, were a gospel group best known for their 1970s hits. But the group began in 1952 and recorded Are You Sure in 1967 for Epic Records. In first-year law, I learned the age-old legal maxim, it's better 1,000 guilty men walk free than one innocent man be convicted. This is why every accused person is entitled to a fair trial in a reasonable time and a not guilty verdict unless the jury is certain of guilt. If we don't stop these interminable trials of political leaders by innuendo and indiscriminate muscle flexing to prove perceived power, we'll end up ensuring no decent person of independent means gives back to Jamaica through parliament, politics, or government. All that'll be left in political leadership are scavengers and scoundrels, peace and love.
So you see, this has become a political hit job, a character assassination, smear campaign against the Prime Minister of Jamaica. That is the route that the PNP decides to take on their quest to seize power, is to attack the Prime Minister personally, to ruin his reputation and ruin his political career. And we know that that is the style of politics of Mark Golding and Peter Bunting. They've done it to members of their own party. And you can see the shambles and the destruction that it's caused. So they have unleashed it on the Prime Minister of Jamaica. So after the IC report came out, you guys saw that they had this press conference at the PNP headquarters or the opposition leader's office. And now everybody's back in Parliament consistently. They're trying now to move a no confidence motion against the Prime Minister, which subsequently led to their walkout. Have a listen to what they said outside of the Parliament yesterday.
Move a no confidence motion in Gordon House, in the House of Representatives. I was prevented from doing so on what I regard to be a spurious basis, a basis that cannot hold water. The basis that was put forward was that the matters on which my motion was based are now sub judice. In other words, because the Prime Minister has apparently sought judicial review of certain matters arising from what the Integrity Commission has decided in relation to his matter. However, my motion is not dealing with the substance of that report, but is dealing with his own conduct as Prime Minister. And I wish to read the motion now so you can hear it. Whereas there is a ministerial code of conduct in place from 2002 that governs the conduct of members of the cabinet, and whereas the Prime Minister did not inform the people of Jamaica that he was being investigated by the Integrity Commission from as far back as August 2023 for illicit enrichment, and whereas the concealment of this information by the Prime Minister is a breach of the Ministerial Code of Conduct that guided the Prime Minister in removing from office ministers serving in the cabinet over which he presided, and whereas the annual reports of the Integrity Commission for 22-23 and for 23-24 stated that several members of Parliament, initially 6 and then 8, were under investigation for illicit enrichment, but none had come forward to disclose that he or she was under investigation. And whereas the Integrity Commission's investigation report on the 17th September 2024 tabled in Parliament named the Prime Minister as being under investigation for illicit enrichment. And whereas the Prime Minister, as Chairman of Cabinet, instructed members of Cabinet not to divulge the name of any member under investigation for illicit enrichment, contrary to the spirit of the Ministerial Code of Conduct. And whereas the actions of the Prime Minister have caused and continue to cause severe damage to the trust necessary for good order and respect for public office, be it resolved that this Honourable House condemns the Prime Minister for not maintaining ethical standards of transparency and openness in government. Secondly, censures the Prime Minister for his acts of covering up and concealment of the names, including his own, of those members of the Cabinet and or Parliament of which he was and may still be aware, but has kept them in positions of influence in the Cabinet with the effect of further undermining public trust in the institutions of government, and declares that the actions of the Prime Minister have severely undermined his credibility and trustworthiness and that he no longer enjoys the confidence of this House. That was the motion that was to be put forward today and hopefully debated next week. We did not want it debated the same day that it was tabled. The Prime Minister is not here in Jamaica. That would not be right or proper. However, we were not allowed to proceed with the tabling of the motion because the Speaker herself had removed herself because the matter affected her husband, and the Deputy Speaker ruled that the motion was improperly brought in breach of the standing orders, relying on the sub judice rule, and so the motion will not go forward. And we think that that is an abuse of the rules of Parliament, and no confidence motions have a very high place in our constitutional arrangements. If a no confidence motion is passed in Parliament, the Governor-General has to dissolve Parliament and call elections. So that is in section, I think, 64 of the Constitution, subsection 5. So for them to block the opposition from bringing a motion on the alleged basis that the matter is sub judice is really, in my view, a bad and sad day for our democracy. Again, it's an example of freedom of speech, freedom of association, our democratic principles. Nothing has been brought so far that warrants any action on his part. And if those accusations are proven to be true, or even if sufficiently credible evidence is brought to warrant a charge, then that's a different thing.
So this applied to Dayton Campbell, but it does not apply to the Prime Minister of Jamaica, who has not been found guilty of anything by the prosecutor or even the Integrity Commission where illicit enrichment is concerned. Now, he's saying that his gripe with the Prime Minister is that he didn't tell anybody that he was being looked into. Is that even appropriate? The Integrity Commission of the country is dealing with the Prime Minister where his 2021 declarations are concerned. They're asking him questions and so on. What the Prime Minister is supposed to do? Go stand up out of the front door of a garden house and say, Jamaica, me under investigation. No, that's not what you do. You give the respect to the IC to conduct whatever they're looking into and let them be. That's what you do. In addition, according to the Integrity Act, you're not supposed to be out there talking about or debating ongoing investigations until after it is tabled in Parliament. It is in a section, I think it's section 53 of the Integrity Commissions Act. Whatever happened to innocent until proven guilty, which applied to Dayton Campbell. So they come to the Parliament with the no confidence motion. Hurriedly so. They even had a speech prepared. Listen to what the Speaker of the House had to say.
Repeated on many occasions that things need to get to the Parliament with adequate time so that we can read and we can ensure we follow the proper procedures. We were in fact notified by email that a motion would come, but it didn't come until just before I got to Parliament. And it does take some time to review and ensure that motions are properly laid. A signed copy of the motion came to me at the desk when Member Paulwell came to the desk during the sitting of the Parliament. And I just came out for a moment a while ago and I note the opposition walking out. I was coming back to tell them I'd gone out because I was just completing my review so that they could go ahead and debate if they so choose. However, even though they heard as much, they continued to walk out.
I have said from day one that Mark Golding and Peter Bunting and Dayton Campbell, they're trying to have another Bruce Golding moment. This is not a Bruce Golding moment. They're trying to have a Bruce Golding moment where Bruce Golding tried to defend Dodos and got caught. Very embarrassing situation. This is not that. So when they're coming, and I think they had a no confidence during that time too against Bruce Golding. So this now, it is nothing remotely close. But they're trying to use that tactic because they've used it similarly within their own party against their leader. And they're trying to use it on the Prime Minister. They're trying to smear him and get him to resign. That's the tactic that they are using. Trying to overthrow him like they did Dr. Peter Phillips. Trying to run him out of government like they run out Lisa Hanna from out of the party. The only thing that Andrew Holness can do at this time is do like what the PNP resistance have done. The PNP resistance have been very fierce against Mark Golding, Peter Bunting, Dayton Campbell, and that clique within the PNP. They have been extremely fierce. So fierce that it came down to lawsuit and death threats and all those kind of things, because that's what Rise United does. But you cannot cower. You have to stand up and you have to fight. I mean, Andrew Holness should have started fighting a while ago, but I guess he was too busy running a country. But the Prime Minister, he has to fight. Politics is one thing, you know. Politics and policies are one thing, you know. But when it comes down now to the character assassination, what them doing to Andrew Holness, that is a different kettle of fish. And you can't fight no normal fight with that. You have to pull out, you have to go in at the arsenal and you have to pull out everything to defend yourself and defend your name. That's what Andrew Holness has to do. So the Prime Minister just started the fight where he is taking the IC to court. And there were reports also that he would sue members of the opposition who are smearing him and trying to defame him. Did you guys know that Mark Golding has not been certified by the IC yet? Yeah, you'd be surprised to know. Listen to the following news reports so you'll have an idea of what the legal challenge is to the IC.
Good morning, Tuesday, October 1, 2024. Well, Prime Minister Andrew Holness, Imperium Holdings Limited, Positive Media Solutions Limited, and Positive Jamaica Foundation Limited have filed in the Supreme Court an application for permission to apply for judicial review in the matter concerning the Prime Minister's statutory declarations and that report into his statutory declarations tabled in the House of Representatives a few days ago. This is a long document. The Prime Minister and those three companies, Positive Media Solutions, Positive Jamaica Foundation, and Imperium Holdings Limited, the three companies that were the center of focus and attention by the Integrity Commission. Those are the four applicants. The respondents, Craig Beresford, Kevin Stevenson, and the Integrity Commission. Holness and the companies, they want leave to be granted for a judicial review of the failure and or refusal of Craig Beresford to act impartially, fairly and independently to carry out his statutory duty to examine the 2022 and the 23 statutory declarations of Andrew Holness pursuant to the Integrity Commission Act. Holness wants a judicial review of the decision to continue or keep the investigation for illicit enrichment open in relation to his 2021 declarations, notwithstanding findings or conclusions that for that year his liabilities were greater than his assets to the tune of $10.46 million, or otherwise there was no unexplained growth in his net worth. He wants judicial review of the decision to embark on, continue, or keep the investigation open into his 2022 declarations, notwithstanding findings or conclusions that for that year his liabilities were greater than his assets to the tune of 5.3 million Jamaican dollars. He wants a judicial review of the failure the finding by Kevin Stevenson, or the decision in all the circumstances, that Andrew Holness's lawful objection as contained in his responses and from his attorneys on his behalf, including in the letter of the 16th of July 2024, is a refusal to provide information which inhibited his ability to make a comprehensive and final assessment of the first applicant's assets, liabilities, and income. Remembering, of course, that Holness is the first applicant. He wants a judicial review of what he says is the impermissible commingling of the relationship and or functions of and amongst the divisions of the Commission and the Commission, resulting in a conflict of interest and or abdication of the duty of the respondents, Beresford, Stevenson, and the Integrity Commission when exercising their statutory functions. He wants a judicial review of the failure of Stevenson and the Integrity Commission to recommend and or issue a public exoneration of culpability on the termination of their first investigation of Holness's 2021 declarations as required by Section 54.5 while improperly including its details in the report of August 30, 2024, such that the benefit of exculpation is lost. Exculpation, of course, means free from blame or guilt. He wants a judicial review of the misuse of his private information by disclosing that private information in a manner that is prejudicial to his rights and interests. He wants a judicial review of the Integrity Commission's misuse of Section 36.3 of the Integrity Commission Act to table a special report in Parliament and make improper and unlawful recommendations to Parliament and or the FID and Tax Administration Jamaica. He wants a judicial review of the findings and or conclusion that there is a potential conflict of interest between him, Andrew Holness, and Norman Brown, who is the chairman of both the Housing Agency of Jamaica and the UDC. And he asks for several orders. Order of certiorari, court process, of course, that seeks a judicial review of a decision by a government entity. He also wants an order of mandamus, which is a court order that requires a government official or entity to perform a legal duty or refrain from illegal action. He wants a declaration that the submission of the reports to Parliament, save for the matters referring to the 4 accounts for tabling, was unlawful and or illegal, having regard to the full terms and effects of Section 54 of the Integrity Commission Act. People, it's a long document. I'm just going through some of the highlights of what he has asked for, what he has cited as the wrong done to him by the Integrity Commission as a body, by Craig Beresford and by Kevin Stevenson. And joining him as applicants in this application to the Supreme Court is OLR, Imperial Holdings Limited, Positive Media Solutions, and Positive Jamaica Foundation. This action was filed in the Supreme Court September 30 this year. We will have much more in subsequent newscasts. Today, the Prime Minister said he was going to court. He has gone to court. The Integrity Commission will have some big questions to answer in court regarding the Prime Minister's statutory declarations. And what he says is their failure to approve, authorize, to sign off on his 2021 declarations while using those 2021 declarations to commingle it with subsequent investigations when the 2021 should have been signed off on and whatever else left as is. He says that commingling makes the public believe that the 2021 declarations are still in dispute when he says the evidence shows that he did nothing wrong and that should have been authorized. He says that the Integrity Commission misused their power and are abusing their power by not so certifying. So it's all happening from here. That's the breaking news this morning.
Yeah, guys, so that is the update. They're trying to move on no confidence against the Prime Minister and pressure him to resign while he is outside of the country, currently in India. I think he should be back in Jamaica by now, if I'm not mistaken, or if not, soon. Guys, make sure that you tune in to the live broadcast tonight, where we will delve into why these 2 investment bankers are trying so hard to overthrow the Prime Minister and the government of Jamaica. We'll go into some exclusive information and details, and I'm also going to have a special guest. So make sure you don't miss that. Keep it locked here to Jamaica Politics Uncovered, where you get all your political news, reviews, updates, your breaking news, everything, excitement. You will get it right here and get it accurate. And we are fierce over here when it comes down to the truth and what is right. Make sure you subscribe, guys. You have a notification on and you are inviting your friends over here. Take care and thank you for watching.